Hello, everyone. I'm Ezgi. I'm a third-year PhD researcher at the University of Turin, also an early-stage researcher at the Sapiens Network, which is a European-funded research project focusing on sustainable public procurement from national, European, and international perspectives. My research project focuses on enforcing sustainability and contract performance within the context of sustainable public procurement. And as such, my brief presentation will be the summary of my research that I've been carrying out in the past 3 years. Apologies for not being able to join to the webinar, but I hope this presentation will provide a good summary of what I intend to present that day. So, as you might have already discussed in July, in the EU, the regulatory framework in which we assess public procurement is Directive 2014-24 on the award of public contracts, also known as Public Sector Directive. This legal framework, within the principles arising from the EU treaties, regulates how contracting authorities in Europe buy work, services, and products. On the other side, when we look at sustainable public procurement, the question that we ask is what to buy. That can be defined through technical specifications, award criteria, and performance conditions, and whom to buy or whom not to buy from, which can be defined through selection criteria and exclusion grounds. Since public procurement rules mainly regulate how to buy, they do not necessarily mandate what to buy or whom to buy from or whom not to buy from. As a result, under the Public Sector Directive, sustainable public procurement is predominantly discretionary. In this legal framework, we can divide sustainable public procurement as green and socially responsible, but more and more these concepts are being changed as well. Instead of green, we have circular public procurement, we have low emissions public procurement, or instead of socially responsible, we have human rights in public procurement or gender responsive public procurement. Also here, it needs to be noted that though under the Public Sector Directive, there is no mandatory public procurement criteria, following the European Green Deal, and it's been almost 5 years, following this framework, there are more and more secondary sector legislation introducing sustainable public procurement criteria. So though the Public Sector Directive is not being changed, the public procurement legal framework is changing. So accordingly, in the legal area, the research has focused on what can be technical specifications, how can we incorporate human rights in public procurement. So we are mainly focusing on sustainability criteria. But what happens is that, or what we don't look is that the incorporation of sustainability criteria in a tender document does not necessarily mean that contract performance will be sustainable. Because it could be that these contracts are being used for greenwashing and social washing, so the obligations undertaken by successful tenders are not actually being delivered. This is why we need to look at sustainable public procurement from a contract compliance, contract enforcement perspective. So what happens after the contract is awarded? What happens is that regardless of the criteria they arise from, whether this is technical specification, contract performance condition, which is a concept we have in the EU legal framework, these become the contractual obligations of the successful tender. As such, we need to look at them as contractual obligations. However, when we look at the ways in which we can enforce these sustainability related obligations, how contractually we can enforce sustainability related obligations, the traditional concepts of contract law fall short because contract law is principally not equipped to answer societal needs. The enforcement concepts such as benchmarking, conformity of goods to fitness for purpose, or quality in the material sense, or allowing a contract to be terminated only when non-performance reaches to a certain severity, like fundamental non-performance, serious non-performance, or serious breach, which is often not the case for sustainability clauses. These contract law concepts fall short. So when we try to take these obligations to court, contract law does not accommodate sustainability, so to speak. So we need a different perspective. What we are looking for in such a case is that whether the performance being delivered matches the obligations undertaken by the successful tender. So what we are actually looking at is whether the contract performed is a different one than that was awarded. This makes a question something to be investigated under ban on contract changes. So what is ban on contract changes, contract modifications? So, in principle, as you might have discussed, EU public procurement rules do not regulate performance of a contract. However, one of the exceptions is contract modification, which is a concept arising from Court of Justice case law and made its way to the Public Sector Directive. The underlying rationale is that because public contracts are awarded through competitive tendering procedures, adherence to the result, the criteria that is being used in awarding the contract should be also complied with during the contract performance. This is an obligation that arises from principle of equal treatment. As a result, in the current framework, the Public Sector Directive, unless they fall under one of the exceptions provided, changes to concluded contracts are prohibited. This equally applies to sustainability obligations. So what happens is that regardless of the contract law concepts, contract law benchmarks that are being used to enforce obligations, like non-conformity, fundamental non-performance, what we can use to enforce sustainability obligations in public procurement contract perspective is when this contract is performed without the underlying sustainability obligations. Is this mainly a different contract than that was awarded? So the issue becomes like this. Non-compliance by the contractor with its sustainability related obligations, failure of the contracting authority to ensure compliance with these obligations, function as a waiver of these obligations. So contract is being changed in a way as if it was awarded without these obligations being incorporated, which makes the contract illegal, the contract modification illegal, and requires the termination of the contract. So what I am suggesting is that we can use this mechanism that is given under the Public Procurement Directive, a mechanism specific to public procurement contracts, to enforce sustainability-related obligations. Because in a traditional or a private contracting setting, it could be that contractor may be tempted not to actually carry out these obligations because they are hard to enforce in a court setting, because they are not leading to nonconformity, they are not fundamental non-performance, allowing contract to be terminated. But in a public procurement setting, we don't have to look at these traditional benchmarks. Rather, we need to look at, is this contract being performed without sustainability obligations, different than the one we awarded with sustainability obligations. What does this mean for contract management? What it means is that in this legal framework, in order to accommodate the ban on contract changes, we need contract management. So contracting authorities should be able to ensure compliance with the sustainability criteria they incorporated, which means that when they incorporate sustainability obligations, they should have the means to check compliance. So beyond material characteristic, they should be using self-reporting. They should be checking through labels and certifications. And then these monitoring tools should be used for the progress. So if there is a non-compliance detected, this should be remediated through self-cleaning, and the contract that was already awarded should be used to make progress. And termination in this framework should be used as a last resort. So to conclude, what I am arguing in this work is that in the EU legal framework, contracting authorities incorporating sustainability obligations should be able to enforce these obligations pursuant to the principle of equal treatment. Once again, sorry for not being able to join you, but this is my email. Feel free to ask me any question. I'm open to discussions, open to chat, and thank you very much.